Good morning. We'll call the hearing back to order, and I think it's next witness for ORS.
Yes, sir, Mr. Chairman. Thank you. ORS calls as its next witnesses the panel of Steve Ham and Willie Morgan. Okay, good morning, Mr. Ham, Mr. Morgan. Mr. Ham, let's start with you, please. Would you please state your full name and occupation for the commission?
Yes, my name is Steve Ham.
Got your microphone on. There you go.
Thank you. My name is Steve Ham, and I have served as special counsel and senior advisor at the Office of Regulatory Staff.
Can you briefly summarize for the commission your background and experience in the field of utility regulation?
I think my best summary is that I argued my first case, which was a Duke case, in the summer of 1978, and I have participated in literally hundreds of hearings, and I've argued regulatory cases in the circuit court and before the Supreme Court on about 40 occasions.
Thank you, sir. And are you the same Steve Ham who pre-filed 11 pages of surrebuttal testimony in docket number 2018-318E on March 25th, 2019?
Yes, sir, I'm the same.
Do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
No, sir.
And if I asked you today the same questions as those posed in your pre-filed surrebuttal testimony, would your answers be the same?
Yes, sir.
Mr. Chairman, ORS had originally filed both public and redacted versions of Mr. Ham's testimony and subsequently filed a revised redacted version of Mr. Ham's surrebuttal on April 9th. After consultation with counsel for the company, ORS understands that the company does not object to Mr. Ham's testimony being made public, and as a result, ORS asks that the pre-filed surrebuttal testimony of Steve Ham be read into the record in its entirety as if given orally from the stand.
Okay, Mr. Ham's pre-filed surrebuttal testimony will be read into the record as though given orally from the stand.
Thank you. And Mr. Ham, did you also file 4 surrebuttal exhibits marked SWH1 through SWH4 as attachments to your surrebuttal testimony?
Yes, sir, I did.
And were portions of your surrebuttal exhibits SWH1 and SWH2 marked as confidential at the request of the company and pursuant to SC code annotated 58-4-55?
Yes, sir, at the time they were marked confidential.
Do you have any changes, edits, or corrections to your pre-filed surrebuttal exhibits?
No, sir.
Okay, thank you. Mr. Chairman, it's ORS's understanding that the company no longer claims confidential treatment of surrebuttal exhibits SWH1 and SWH2, and for that reason, ORS asks that the pre-filed, surrebuttal exhibits SWH1 through SWH4 of Steve Ham be entered into the record without redactions as the next hearing exhibit.
Okay, Mr. Ham's surrebuttal exhibits SWH 1 through 4 will be entered as exhibit number 67.
Thank you, sir. Mr. Ham, have you prepared a summary of your testimony?
Yes, sir, I have.
Could you please provide a brief overview of your surrebuttal testimony in this proceeding?
Yes, sir. Mr. Chairman, members of the Commission, good morning. My testimony addresses one of the critical issues now before this Commission. ORS recommendation to disallow certain DEP legal expenses properly serves to encourage careful contract negotiation and complete management understanding of all provisions of the agreement. ORS's position to disallow legal expenses helps to align the cost and benefits of entering into agreements and litigation and ensures that the company carefully manages its operations and considers the cost that in pursuing litigation could potentially have for its customers. Sound policy requires that the company should not be able to insulate its ratepayers by externalizing costs to customers. DEP management failed to meet its legal and operations obligations when the North Carolina Business Court ruled last August that DPA failed to successfully defend its positions regarding the meaning of certain terms of the DEP agreement with certainty. Management failure to vindicate its position resulted in DEP agreeing to pay certainty almost $90 million in liquidated damages. DEP's management failure cannot be the responsibility of DEP customers who had no participation in any aspects of the negotiated agreement. My testimony addresses the company legal expense recovery position presented in the testimony of DEP witnesses. The company suggests that all the legal expenses the company included in this case are fair and reasonable and should be approved by this commission. However, the company bears the regulatory burden to provide substantial evidence to the commission that any proposed legal expense should be paid by company customers and not shareholders. The company has not met that basic regulatory requirement regarding the legal expenses sought in this case. The public policy role of this commission is to carefully examine an expense before any decision regarding approval of any expense. In this matter, ORS recommends that the commission first examine the legal expense in question and then determine why that expense was incurred by the company in the first place. Was a legal expense incurred because the company was charged with violations of applicable law in connection with its operations? If so, the commission needs to be presented with the detailed facts of the alleged violation and the operating conduct of the company before allegations of violation of law were raised by whatever legal authority or customer involved. Management decisions and conduct are directly relevant in determining if customers should be forced to pay any specific legal expenses in their electric rates. This commission has already demonstrated in the recent CWS case that it is prepared to reject company legal expenses resulting from operating violations in the operation of the company. The South Carolina Supreme Court has previously ruled that the commission should not reward a company for violations of operating standards, whether state or federal. Fair and reasonable rates should not include expenses solely the responsibility of actions of management. In this case, the company has provided no cogent and relevant evidence regarding the legal expenses that ORS has challenged. ORS is recommending that the commission reject treating our positions and legal expenses as an allowable regulatory expense in this case. The company provided very vague justification for the coal ash litigation expenses that ORS is challenging. Those justifications do not address the reason the expenses were incurred initially. From reviewing the documents, the commission only knows a limited and insufficient amount of information for the legal expense information supplied by the company. DEP has not provided the commission with specific and understandable information demonstrating that all expenses should be paid for by DEP customers in the first place. The term substantial evidence does not include the reason the legal expense was incurred in the first place is not the substantial evidence required by decisions issued by the South Carolina Supreme Court. Sound regulatory policy needs to be consistently applied based on evidence presented to the Commission. ORS's recommendation on this issue are consistent with the policy applied in the CWS case and are consistent with the decisions issued by the South Carolina Supreme Court. A regulatory policy employed by this Commission can only be relevant if it is consistently employed in rate-making decisions.
Thank you, Mr. Ham. Good morning, Mr. Morgan. Would you please state your full name and occupation for the commission?
Good morning. My name is Willie Morgan, and I'm the Deputy Director for Utility Rates with the South Carolina Office of Regulatory Staff.
Thank you, sir. Are you the same Willie Morgan who pre-filed 9 pages of direct testimony in docket number 2018-318E on March 4th, 2019?
Yes, I am.
Do you have any changes, edits, or corrections to your pre-filed direct testimony?
Yes, I do.
Could you please identify those edits?
On page 3 of 9 of my direct testimony, line 16, the years that are given there, 2033 and 2034, should be changed to 2030 and 2046.
Thank you, Mr. Morgan. And if I asked you today the same questions as those posed in your pre-filed direct testimony, subject to the changes you just indicated, would your answers be the same?
Yes, sir.
Thank you. Mr. Chairman, ORS had originally filed a confidential version of Mr. Morgan's testimony and a public version. ORS would ask that the publicly filed version of Mr. Morgan's testimony be read into the record as if given orally from the stand, subject to the change outlined by Mr. Morgan, and that the unredacted version be held under seal pending further order of the Commission.
Mr. Morgan's pre-filed direct testimony as corrected will be read into the record as though given orally from the stand, and that's the public version. Confidential version will be held under seal.
Thank you, sir. Mr. Morgan, did you also file 3 exhibits marked WJM1 through WJM3 with your pre-filed direct testimony?
Yes, sir.
Do you have any changes, edits, or correction to these exhibits?
No, I do not.
Mr. Chairman, ORS originally filed WJM1 and WJM3 under seal with the Commission. The company withdrew its claim of confidentiality regarding WJM1, and ORS filed WJM1 publicly on April 9. ORS would ask that WJM1 and WJM2 be moved into the record in this case. We would also ask that WJM3 be moved into the record, but that it remain under seal at this time.
Okay, Mr. Morgan's exhibits, WJM 1 and 2 will be entered as exhibit number 68. The confidential WJM number 3 will be entered as exhibit number 69 and held under seal.
Thank you, Mr. Chairman. Mr. Morgan, are you the same Willie Morgan who pre-filed 6 pages of rebuttal testimony in docket number 2018-318E on March 25th, 2019?
Yes, I am.
Do you have any changes, edits, or corrections to your pre-filed rebuttal testimony?
No, I do not.
And if I asked you today the same questions as those posed in your pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Okay, thank you. And Mr. Chairman, again, ORS had originally filed a public and a confidential version of Mr. Morgan's rebuttal in consultation with the company. ORS understands that the rebuttal testimony of Mr. Morgan may be made a part of the record in its entirety without any redactions. So ORS would ask that the pre-filed rebuttal testimony of Mr. Morgan be read into the record as if given orally from the stand.
Mr. Morgan's pre-filed rebuttal testimony will be entered into the record as though given orally from the stand.
Mr. Morgan, have you prepared a summary of your testimony?
Yes, I did.
Okay. Well, let's proceed with that quickly if we can. Mr. Morgan, what is the purpose of your testimony in this proceeding?
Mr. Chairman and other members of the Commission, the purpose of my testimony is to set forth the findings and recommendations resulting from ORS examination of the company's application and to address certain pro forma adjustments.
What are those pro forma adjustments?
Adjust for reserve for end-of-life nuclear costs, amortize deferred cost balance related to SC AMI, normalize for storm costs, remove certain legal expenses, adjust for ongoing payment obligations with Certainty Gypsum NC Inc., and adjust for nuclear materials and supplies inventory at power generation sites.
Could you please explain the company's proposal to establish a reserve for end-of-life nuclear costs?
ORS recommends the Commission deny the company's request for approximately $2.9 million for a reserve fund for its end-of-life nuclear costs. These costs are not known and measurable, and the date of retirement of the nuclear unit is uncertain.
And could you please explain the adjustment to amortize the deferred cost balance related to South Carolina AMI?
Commission Order Number 2018-553 granted the company's petition for an accounting order to defer the incremental operating and maintenance expense and the depreciation expense associated with the company's rollout of AMI. ORS recommends the company be allowed to amortize these costs over 15 years, which is the service life of the AMI meters.
And could you please explain the adjustment to normalized storm costs?
Company Adjustment Number 20 normalizes storm restoration expenses in the test year to a 10-year average, resulting in an increase in test year expenses of approximately $7 million for South Carolina retail. Due to fluctuations in annual storm restoration costs, ORS recommends eliminating the expenses in the highest and lowest years and to use an 8-year average expense level. The company's adjustment adds an inflation adjustment to its 10-year storm expense average to determine its storm expense adjustment amount. ORS recommends the Commission reject the inflation adjustment as it shifts all risks away from the company and onto the customers. The inflation adjustment proposed by the company is not known and measurable. It is speculative and is based on generalized data for the economy.
Could you briefly explain ORS's adjustment to legal expenses?
ORS adjusted non-allowable expenses to remove litigation expenses attributed to legal action related to coal ash. As detailed in ORS Witness Whitliff direct testimony, the company violated state and federal laws which resulted in damages to the environment. The legal expenses are not related to providing adequate electrical service to customers, and customers derive no benefit from the expenditure. These legal costs should be the shareholders' responsibility, which in turn incentivizes the regulated utilities to operate in compliance with federal, state, and local laws.
Please explain ORS's position concerning payment obligations associated with the Certainty Gypsum NC Incorporated case.
For the company's request to adjust for ongoing payment obligation, inclusion of any payment obligation to Certainty stemming from this litigation as an allowable expense, forces ratepayers to pay for DEP's failure to comply with the terms of an agreement. Furthermore, the ongoing payment obligations are not related to providing adequate electrical service to customers, and the customers derive no benefit from the expenditure.
Okay, thank you. Mr. Morgan, is it your understanding that the company and ORS have entered into a stipulation that covers several points in your testimony?
Yes, I do.
Okay. Yeah, Mr. Chairman, I would apologize. That's my oversight. That has been e-filed, we understand, and so we could have shortened that, and I apologize because I know your time is valuable. Thank you, Mr. Morgan.
Thank you.
The panel is available for cross-examination and questions from the Commission and parties.
Okay, thank you. Okay, Ms. Ferguson, Mr. Neal, cross. Okay. Mr. Guile.
Gentlemen, thank you for your testimony. No questions.
Thank you. Mr. Elliott.
Please, Mr. Chairman.
Mr. Morgan, indulge me. I've got a few questions for you.
Okay.
I don't think you'll need the Elmo for this, Mr. Morgan, but I thought it was pretty impressive, and so I wanted to put it up for everybody to see. All right, Mr. Morgan, you are, as I understand it, a licensed professional engineer, correct?
Yes, sir.
And prior to your employment at the ORS, you were employed by DHEC as an environmental engineer associate, correct?
That was my initial employment status, and there were promotion along the way.
Yes, and you were promoted to the position of permitting liaison, where you assisted industries and the public with environmental permitting requirements in South Carolina, correct?
Yes, sir.
And your assistance in this regard included providing information about air quality, solid and hazardous waste management, and water and wastewater management requirements. Is that correct?
Yes, sir.
And you were employed by DHEC for about 19 years, correct?
Yes, sir.
Now, I want to draw your attention, if I may, to this Robinson Plant coal ash pond. You are aware that Progress in this case is seeking to recover ultimately about $179 million from its ratepayers for the coal ash remediation from that pond. You're generally aware of that, are you not,
Yes,
sir?
sir.
And they're seeking some recovery of some amount, $11 million perhaps in this case. I don't have that number, but they're seeking recovery here, correct?
Yes, sir.
And you understand that it is the company's position, and you understand that it is the ORS position, that because the Duke Progress and entered into an agreement with, a consent agreement with DHEC, that it is by virtue of that agreement with the regulator that that recovery of those costs is justified. You understand that generally, don't you, sir?
Yes, sir.
All right. Now, what I want to do this morning is just sort of pick your brain a little bit about your experience at DHEC and how it might help inform the commission. Now, as I understand it, in the hazardous waste area, hazardous waste sites must be permitted and regulated by DHEC. That's correct, isn't it?
Yes, it's permitted under the subtitle C landfill requirements.
All right, and as are, I guess, all landfills, hazardous or otherwise, correct?
Well, the hazardous under the subtitle C, and then the non-hazardous as what we've been discussing relative to coal ash disposal, subtitle D.
All right. And so this pond was regulated under the hazardous subtitle D. Now, as a part of DHEC's regulatory process, DHEC would make regular inspections of this coal ash pond and any landfill, correct?
That is the procedure, yes, sir.
And you made, in your experience at DHEC, you actually made inspections of landfills, did you not?
On a regular basis.
And you made those, the regular basis was a quarterly basis. Those inspections were made quarterly, were they not?
For some, and we had one, of course, the hazardous waste landfill. We inspected that one more frequent.
Good. And as a part of your inspection, you would pay careful attention to determine whether or not the landfill in question met or exceeded regulatory requirements, wouldn't you, sir?
Yes, yes, sir.
All right, and in inspecting these landfills, you would be looking for, you would be looking at whether or not the area was appropriately covered by soil and properly grassed, correct?
Yes, sir.
And you would be looking to determine whether the landfill operator, in this case Progress, met its obligation to control dust, odors, litter, vectors, fires, and open burning, correct?
Yes, sir.
And And in making an inspection of this Robinson plant landfill, you would, on your quarterly inspections, inspect the property to make sure that the site was maintained and operated in a manner to protect the groundwater and surface water quality at the location of the coal ash pond, correct?
That would be part of the evaluation process, yes, sir.
And in making your inspections, you had a form that was governed by a regulation, a DHEC regulation, that you would have to fill out on every occasion, correct?
Yes, sir. The form was generated based on the regulations, yes, sir.
Very fine. Indulge me a moment. Mr. Chairman, I'd like to mark an exhibit for identification, please.
Mark it as number 70.
I don't have copies for my friends in the middle.
How about your friends up here? That's what.
Well, you can have this one when I'm through. I just understood we needed one copy to be put into evidence, Mr. Chairman. I hope you'd indulge me. Mr. Chairman, ORS been very kind. All right, now, Mr. Morgan, you're younger than I am, and I'm going to assume that your eyes are better. But I show you, I've zoomed in a little bit to show you this document, which is labeled Structural Fill Inspection Form, Regulation 61-107.19, Part 2. Do you see that language?
Yes, sir.
And I did give you a moment prior to your testimony to inspect this form, and can you identify this as a DHEC form that is promulgated for the purpose of recording the results of an inspection at landfills such as the one at Robinson, correct?
Well, the form was generated to help and assist the inspector with the review of the facility to ensure compliance with the regulation.
Excellent. Thank you for the help. And in this particular case, the structural fill inspection form, the official DHEC form, is for the H.B. Robinson plant, correct?
Yes, sir.
And it shows a date of 6/9/15, June 9/15, does it not?
Yes, sir.
And of course, it identifies the county and the permit number, correct?
Yes, sir.
And the reason for the inspection is routine, correct?
Yes, sir.
And as I understand your testimony, what is routine in this case is a quarterly inspection, and so this would be the quarterly inspection for the time in question, correct?
Yes, sir. I mean, I would add, though, that from time to time, if there are issues that are identified for whatever reason, someone call in as a complaint or whatever may dictate a need for an inspector to go out to the site, one would be generated then as well.
All right, good. Thank you. And that's helpful. Now, I've zoomed out a little bit. I'm going to zoom back in, but there's a legend in what is now the middle of the screen on the Elmo, and I would draw your attention to number 1. The language is meets or exceeds regulatory requirements. Do you see that language?
Yes, sir.
And so it's fair to say that if the inspector found that the landfill at the time met or exceeded the regulatory requirements, that he would put a number 1 there, correct?
Yes, sir.
Or in this case, I think probably a she. Now, I've just blown it up so we can see the parts, but the first part, facility entrance area, fill area, Regulation 61-107.19, Part 2. Do you see that language?
Yes, sir.
And so there's sort of a laundry list there, and I won't read every one, but there are certain basic matters that the inspector needs to observe at the outset, such as was there an attendant present, and was the area properly staked, and so forth. Do you see that?
Yes, sir.
And there's also some language here, waste reduced in size to less than 1 cubic yard in place, and I don't fully understand that, but it was compliant, right? It says yes, circle
Yes.
Y for yes.
Yes, sir.
And there's a question number 8, monthly cover, Regulation 61-107.19, Part 2, E7. The question, the point to be observed is cover applied monthly with at least 6 inches of soils or other department-approved material. Do you see that?
Yes, sir.
And the inspector found that it was properly covered, correct?
Yes, sir.
And the inspector found that the condition of cover on inactive or closed areas met or exceeded the regulatory requirements, correct?
Yes, sir.
Because there's a number 1 there by, in the blank by 9, and when you look at the legend above, it reads meets or exceeds regulatory requirements, correct?
Yes, sir.
Mr. Elbow is not going to cooperate. Now, indulge me, Mr. Chairman. Now, the next section, beginning with number 10, and this is the one I really want to draw your attention to, is labeled Environmental Protection, Regulation 61-107.19, Part 2E. Do you see that language?
Yes, sir.
And number 10, the matter to be considered by the inspector under number 10 is control of dust, odors, litter, vectors, and fire/open burning. And the landfill on this occasion met or exceeded the regulatory requirements, correct?
That's what the inspector recorded for that time.
As was her duty under the regulation and under the terms of this inspection report, correct?
Yes, sir.
She had to record the correct observation, correct?
Yes, sir.
Thank you. Now, number 11, site maintained/operated in a manner to protect groundwater and surface water quality. Do you see that language?
Yes, sir.
And the inspector found that, yes, the site was maintained and operated in a manner to protect the groundwater and the surface water quality, correct?
Yes, sir.
And then last, there's a list, number 12 through 15, of closure of entire structural fill area under Regulation 61-107.19. And there are a number of questions about the soil cover and the slopes and so forth. And what the inspector found was that the cover and the slopes met or exceeded DHEC requirements for the operation and maintenance of that coal ash pond, correct?
Yes, sir.
And then the inspector would make an observation as to who was present. We'll see from this form that Ms. Watson was the inspector, Mr. Gilbert was the Duke Progress representative, and she makes a note that apparently the last date waste was added was before 3/15, and I don't know whether that's March 15 or if that's March of 2015 or 3/15 of this year, and then probably the same thing. And then some reference to a final deed report. Do you see that language?
Yes, sir.
And then it's signed by the inspector, Ms. Watson. Do you see that?
Yes, sir.
All right, Mr. Chairman, I'd move this into evidence at this time.
It'll be entered as number 70.
70, thank you, sir. Now, Mr. Morgan, as I understand it, that with respect to landfill violations, as with, and what I'm more familiar with, and you and I have worked on over the years, violations of NPDES permits, if an inspection, whether it's self-reported in the case of the water and sewer companies or whether it's an inspection by, say, Ms. Watson in the case of this landfill, if the inspection shows a violation of a regulation, a DHEC regulation, DHEC will notify the company and give it notice of the violation, correct?
Yes, sir.
And when you and I do business on the water and sewer side, we shorten it to NOV, correct?
Yes, sir. If it's of that level, sometimes it could be simply a warning letter, and that's those violations that are not considered as serious.
Yes, sir. And if there's a serious violation, then with respect to the landfill, as with the water and sewer regulation, DHEC will give a notice of violation and require the regulated utility to come into the DHEC offices for a conference to determine whether a violation occurred, and if so, what the penalty should be, correct?
Yeah, sometimes, though, it could simply be a requirement to provide a response as opposed to actually showing up for an enforcement conference.
All right, sir, and I understand that. And on behalf of all lawyers representing utilities everywhere, we always hope it's the letter and not the conference. But if it's serious enough, the utility, in this case Progress, would be called in for a conference, correct?
Yes, sir.
And the result of these conferences, in my experience, is almost universally one where the utility agrees that it is in violation of its permit and seeks to mitigate whatever penalty DHEC seeks to impose. Is that not your observation as well?
Those are the type you would hope for if it's something that led to an actual enforcement action. You hate to have to deal with an administrative order, which is where the company has failed to cooperate in addressing the matter.
Right, right. And so ultimately, if there's a notice of a violation, it's substantial, there's a status conference, there will be a consent order that will result, correct?
Typically, yes, sir.
And that consent order...
Or compliance order.
All right, sir. And that consent or compliance order will set out certain findings, which would include any violation of the utility's permit, correct?
Yes, sir.
And typically, although not always, but typically, a violation of the permit will result in a fine by DHEC, correct?
Fine or a contingency penalty, whereas if the company addresses the matter in a timely manner in accordance with that order, the penalty will not be assessed. And if they do not, then the penalty is automatically triggered because they failed to comply with the order.
Right. So the document would set out a penalty.
Yes, sir.
And you know, if you beg for mercy strong enough, you might get put on probation.
Right.
Let me show you hearing exhibit 42, if I may. I'm going to put it on the Elmo. It is labeled In re Duke Energy Progress, Inc., H.B. Robinson Steam Electric Plant, Darlington County, Consent Agreement 15-23-HW. Have I read that correctly?
Yes, sir.
And I think you've had an opportunity to at least review this consent agreement as a part of your duties at ORS, correct?
Yes, sir. It's a part of one of our witness testimony in terms of their exhibit.
All right, sir. And if I were to draw your attention to the findings of fact on pages 2 and 3 of the document, I'll just set it up here for demonstrative purposes, would I be correct in saying that there are no findings of fact in this consent agreement demonstrating that Progress violated any of the terms of its permit for its landfill pond at the Robinson plant?
Yeah, when I read it, I did not see any such.
All right, sir. And if it makes you feel better, the two preceding witnesses have not been able to find a finding in the order either. And I would then ask you if you, in your review of the order, were able to ascertain whether there was a fine or a penalty assessed against Progress as a part of this consent agreement 15-23-820-HW.
No, sir, I did not see that.
Last, I want to show you a paragraph 16 of the consent agreement we've been discussing, which is found on page 10. And I'm going to ask you this. And you feel free to read whatever of this document you'd like to read. I would remind you it's the last morning of the last day of the hearing, so use your discretion. But if you look about halfway down that paragraph, I see this language. I'm going to read it and ask you if I've read it correctly. Once the department has approved the final report, the department will provide Duke Energy a written approval of completion that provides covenant not to sue to Duke Energy for the response actions specifically covered in this consent agreement, approved by the department and completed in accordance with the approved work plans and reports. Have I read that language correctly?
Yes, sir.
In your experience at DHEC, for the 19 years or so you worked at DHEC, and from your observations in the last 15 years or so at the ORS, would you agree with me that it is unusual, if not rare, that a consent agreement or order from DHEC will include a covenant where DHEC agrees not to sue the regulated entity?
I have not seen that in any of the orders that I've reviewed or were a part of formulating while I was at DHEC, or even since I've been here at ORS. I have not seen that language.
Very fine. Thank you so much, Mr. Morgan. Mr. Ham, I just have a kind of a short line for you, if I may.
Short is the operative word.
Yes, sir. Now, you are testifying in your capacity as special counsel and senior advisor in the legal department at the ORS, correct?
Yes, sir.
And in your capacity as a special counsel and senior advisor, is it fair to say that you are generally familiar with the issues raised by the Office of Regulatory Staff in this docket?
Yes, sir.
And as a part of that, you are aware that an issue has developed over certain O&M expense associated with the Customer Connect project, are you not?
Mr. Chairman, we have an objection. I am fully aware that we have a tradition of open cross-examination in proceedings before this commission. And I'm also aware that we allow friendly cross-examination by parties that are aligned. I've engaged in such cross-examination myself in the past. However, the commission has an obligation to conduct the hearing in a way that allows all parties to have fair notice of the allegations and the evidence that they're going to be confronted with and to respond to it. That arises from the Due Process Clause of the U.S. Constitution and Article 1, Section 22 of the South Carolina Constitution. We've talked about that earlier in this proceeding, that provision. This commission has adopted rules requiring the pre-filing of testimony in order to carry out that, and that lets people know this is what this witness is going to testify about, and you then respond. We have rebuttal and surrebuttal. Mr. Ham was a surrebuttal witness testifying on certain limited subjects, and he's done that. Mr. Elliott is now proposing to ask him to offer expert opinions on subjects beyond the scope of his surrebuttal testimony. And it appears that this is pre-planned friendly cross-examination coordinated in advance. I got up quickly to try to prevent it and try to put our objection on the record, but we saw something similar on Monday when the ORS attorney cross-examined the energy users witness Kevin O'Donnell. There was a question asked, and Mr. O'Donnell just happened to have the calculations in front of him on a piece of paper. And Mr. O'Donnell ended up testifying on friendly cross-examination to subjects well beyond the scope of his pre-filed testimony. So we think that on this cross-examination of a surrebuttal witness under these circumstances by a party aligned with the ORS, the cross-examination should be limited to the subjects that Mr. Ham covered in his surrebuttal testimony, and he should not be allowed to go beyond that in order for the commission to enforce its own rules that allow for for fair hearings. So, thank you very much.
Mr. Chairman, it's open cross. I have brief cross-examination for this witness. The ultimate question I have for Mr. Ham deals squarely with the certaintied contract dispute, and I need about 2 questions to set that up, and then I'm going to ask Mr. Ham the applicability of the substance of his testimony, the contract action for certaintied, to these other issues in the case. I think it's fair, and it will be brief, and Mr. Ellaby should not be surprised.
Okay, I'm going to allow you these questions, these 2 questions, but we need to keep it very narrow and with what, with what he's proposed.
You will see it. You will see that it will be so. All right. So, Mr. Ham, you are aware that Duke witness Retha Hunsicker testified in this docket in support of the recovery of certain O&M costs associated with the Customer Connect program, are you not?
Yes, sir.
And I would put on the Elmo her summary, our portion of it, and I will ask you, this is strictly off her, it's just a copy of her summary, and I will ask you if Ms. Hunsicker did not testify as follows: the company's calculation of incremental O&M expense for 2019 and 2020 clearly meet the known and measurable standard because, 1, the company has entered into fixed contracts with multiple vendors to develop the program. 2, the contracts contain provisions requiring the company to provide specified levels of internal labor to support the work. And 3, the fixed contracts contained specified price terms. Have I read that correctly?
Yes, sir.
And so my question to you is, Mr. Ham, you would agree with me that that contracts, no matter how binding, are not necessarily known and measurable, are they?
Well, contracts are binding, and depending on the terms of the contract, it may not be known and measurable, but depends on the timing of the contract.
All right, and you would agree with me that while the company might have thought the certaintied contract was known and measurable, it turned out to be anything but known and measurable, didn't it?
Yes, because DEP was unable to convince the judge in North Carolina that its view of that contract was supported by the language, and the court rejected that position.
Which is not disputed by the company at this point now, because they've settled, correct?
Well, yes, they settled, but it's a final judgment, and there's no appeal, and the settlement does not change the fact that there's a court order in North Carolina issued in August of 28 regarding the dispute between Duke and the certainty subsidiary.
And so the bottom line is that this contract ended up costing Duke Progress about $90 million, if I understand your testimony correct. Am I right?
It cost $90 million. They're seeking to have customers pay for their failure to understand their own contract, which ORS is contesting.
Very fine. Thank you, Mr. Chairman. I have no further questions.
Thank you. Nucor, Mr. Smith, Mr. Lavanga. Company.
Thank you, Mr. Chairman. Good morning, gentlemen. Mr. Morgan, just to be clear, after the questions Mr. Elliott asked you about the Robinson remediation expenses, ORS is supporting recovery in rates by DEP of the remediation costs associated with the Robinson coal ash cleanup, correct?
Yes, sir.
And the ORS position is that that was pursuant to an agreement with DHEC and a state policy, and therefore South Carolina ratepayers should pay those costs.
Yes, sir.
And are you aware that the remediation, the excavation, and of the coal ash ponds at the Robinson plant is consistent with what's being done at the other coal ash ponds throughout the state of South Carolina?
There are some similarities. There are some differences.
But the Santee Cooper ended up excavating all of its ponds, correct?
I'm not certain of all of that, but I understand that they were in the process of doing some of that.
And SCNG also?
Yes, sir. I'm aware they've done some of that.
Okay. Thank you, sir. Mr. Ham, just a few questions for you, sir. You talked about the company's responses, and you attached to your rebuttal testimony the company's responses to the ORS AIR's Audit Information Request number 43. Are you aware of the supplemental responses that the company filed on April 3rd and April 7th to those requests by ORS?
Yes, sir, I am.
Okay. Have you reviewed those, sir?
Yes, sir.
Just look like the information. Excuse me.
Yeah. It's similar to the stack of documents.
All paper.
I'm going to take it on faith, and I mean this seriously, respect that what you're representing is in fact what you placed on next to the court reporter.
Yes, we'd like to we'd like to introduce the company's supplemental responses to the supplemental response to number 43-4, audit request 43-4, audit request 43-2, and audit request 43-5. And these supplemental responses were provided to the ORS on April 3rd for the response to 43-4, and on April 7 for the response to 43-2 and 43-5.
Sierra Club objects to the receipt of these documents and evidence. They're untimely. The record in this case is determined by...
Let's get a microphone, Mr. Guy.
Chairman? Hello?
There you go.
Chairman, Sierra Club would object to receipt of these materials and evidence. You know, the record in this case has to close at some point. I understand the point of ORS's testimony to reflect the submissions or lack thereof by the company at the time they were due. Now, we honored a pre-hearing schedule that required the pre-filing of direct and rebuttal testimony and the timely filing of exhibits supporting that testimony, all pursuant to the same logic that Mr. Ellaby advanced in his last objection that was rejected by the commission. And that is that there's a due process element that works both ways in this case. And you should judge the adequacy of the company's evidentiary submissions based on the evidence that they timely submitted in accordance with those orally pre-hearing schedule. To supplement their showing by April filings, and that's what I understand Mr. Ellaby to submit with regard to the massive stack of documents sitting before the court reporter, which has not been served on my client or any of the other parties that I know of, would simply violate basic principles of due process that the company has insisted the commission follow. So the question is, you should judge the evidence at the time it was required to be submitted, not bootstrapped at the 11th and a half hour, because this is the last day, the last morning of the last day of the hearing. And we simply are in no position to intelligently respond to this, nor I submit should ORS be responsible for responding to it at this late hour either. So we object on the grounds that these submissions are untimely and that it would deny my client due process for the commission to receive them at this hour.
Mr. Chairman, probably half the exhibits in this record are exhibits that were introduced at this hearing on cross-examination. And Mr. Ham's testimony says, makes a point of the inadequacy of our response, and we simply want the commission to know that a supplemental response was submitted, and we think that it ought to be included as part of the record in the case, and could be given the weight that the commission determines is appropriate.
Okay. I'm going to overrule the objection. We're going to accept these and assign the appropriate weight to them. We're going to accept it into the record.
Thank you, Mr. Chairman. Gentlemen, no further questions.
Commissioners. Sir. 71. Commissioner Belzer, it's time for commissioner questions. Or you can ask Mr. Ellaby.
Mr. Ellaby, can you tell us again what that hearing exhibit is? What comprises that exhibit, please?
The supplemental response to audit request 43-4, the request was, could you please elaborate on potential insurance recovery for coal ash, including in the explanations for legal expenditures? And there's a response, several page response and an exhibit. The supplemental response to the 43rd audit request 43-2 is of those coal ash litigation expenses identified, please identify what account they are booked to and the SC retail portion that was included in the company's application for recovery and rates in this docket. And this is a supplemental response. There was previously a spreadsheet was provided. This is a supplemental response with additional information, backup information that was provided.
So they're all related to supplemental responses to litigation expenses?
Yes, ma'am.
Thank you.
Those are they're supplemental responses to the discovery request that Mr. Ham referenced in his rebuttal testimony.
Thank you.
Okay. Yes, sir.
Mr. Chairman, just to make the record complete, I'd also assert a lack of foundation and a hearsay objection. Mr. Ellerby didn't even show the documents to a witness, let alone offer a witness who could establish a proper foundation for these documents, or one who could establish that they aren't hearsay. I mean, it's simply a stack of paper that would be highly improper for this commission to rely on those records under these circumstances to undermine an ORS or other parties' contention in this case. They've offered no witness to support these documents. I can't cross-examine a set of documents that haven't been provided. So I'd object in addition and move to strike on the grounds that these documents lack a foundation and represent hearsay.
Mr. Ham did acknowledge that ORS had received these discovery requests, discovery responses, and that he had reviewed them, This is exactly the type of document that's come into evidence throughout this case, both in part of the pre-filed direct and a great deal of it on cross-examination. I also have been informed that the parties to the case were served with these responses. So these supplemental responses were served on the other parties in the case, including interveners.
Last point, just to make the record. The fact that other documents are accepted without objection, I note, or where an objection has been asserted and overruled by the commission, does not provide any precedential support for receiving these documents. I do object to these documents on the grounds that they have been, that I've asserted. And to the extent they've been served on me, I've never seen them, and I don't know what that means, served on the other parties. Are they hidden in an ORS website? Are they in a filing of some sort? Service has not overcome any of the objections that I've asserted, even if they have been indeed served. So the point is, the fact that this commission has adopted, without objection from a party, a relaxed rule of evidence on some other exhibit does not provide blanket authority to receive these documents with no company witness on the last day of the hearing, obviously intended for the commission, not just for curiosity sake, but to rely on. I mean, unless the company's prepared to stipulate that they don't offer these documents for proof of the matters asserted, proof of the truth of the matters asserted, then they do suffer from the hearsay limitation and the lack of foundation limitation. And I renew my motion to strike.
Okay. I think that the foundation that they're on may not be the strongest, but I think we can assign the appropriate weight to them, to these documents, to have them in the record. So, Mr. Gall, I'm going to overrule and thank you for, and take notice of your objection. Commissioners. Commissioner Urban.
Mr. Ham, we've had a great deal of testimony and evidence presented about whether certain coal ash related expenses required by CAMA in North Carolina should be allowed or disallowed by ratepayers in South Carolina.
Yes, DP Whitliff offered that testimony to this commission yesterday.
And so you were here to hear that testimony?
I was, yes, sir.
Do you have an opinion based on the testimony and evidence presented as to whether or not these expenses should be allowed?
Well, let me first make sure we have challenged, as you are aware, the litigation and legal expenses related to that. And then we've also challenged whether or not ratepayers ought to pay what the DEP witness referred to as the incremental costs resulting from the passage of the CAMA legislation.
What litigation expenses specifically do you challenge?
Coal ash litigation?
All coal ash litigation?
Well, yes, but if you'll let me,
Yes, sir.
I'd like to lay the foundation.
Yes, sir.
And it's going to take me a moment, but I think it would be of assistance to the commission. With your permission, I'll try to do so.
Thank you.
As this commission is aware, a Duke operating unit in North Carolina, the Dan River unit suffered a massive breach with the blockage of the tubes associated with a coal ash basin. That discharge was 39,000 tons of coal ash and another 27 million gallons of coal ash water. I put that down as the predicate. I think it's extremely important that you recognize exactly what happened. Duke pled guilty to criminal negligence. Duke pled guilty to criminal negligence, and I made it a point to go look it up because I thought one of you might ask, and I want to remind you what the definition is in North Carolina. Criminal negligence means recklessness or carelessness that shows a thoughtless disregard of consequences or heedless indifference to the safety and rights of others. They pled guilty to it, which is that is a very significant ruling. Once that came into place, because Duke has made the comment, oh, nobody's paying for any of those costs, and it is our position that the evidence, I don't care whether it's 2 pages or 20,000, the manner in which they have collected and submitted that information, I don't believe can even possibly be considered substantial evidence. And I want to give you some examples because I have personally, and I want you to know, maybe you did the same thing when you got that late filed report 56 in DC. I had to go out and get, let me say this, y'all's eyesight may be a heck of a lot better, so my having to get a magnifying glass may be more of a reference to my eyesight, although I doubt that it is because I had to use this. I have examined every one of those pages. And I believe that we pull a page out randomly and hand it to you, Your Honor. You've been a judge. I don't believe there's any way you could determine what those references are to. You don't know who the parties were. And I think it's distinctly likely, but again, our position is if they can't prove their case with clarity, then they don't meet the standard or burden of proof. And I'll give you an example. If you look at the documents, you'll see entries for defense of state litigation in coal ash. The settlement that took place was subsequent, obviously, to the spill, and some of those go into 2016 and 2017. I think it's rather disingenuous that the company tells this commission and the media, oh, the citizens and customers are not paying for that, when one of the listings, several of the listings in there show defense of state action. And if you follow through, and I looked at each individual law firm entries, and you see entries of several law firms. One of the difficulties that I was having as a lawyer over the years, I've had clients ask me to review legal bills that they had gotten for whatever services. And I mean, I have clients that till I left 20, 25 years, and they would ask me to review it. And I have done so on many occasions. The descriptions contained in these documents are summary at very, very most. And as I know you'll notice, there's all kinds of redactions. And given the redactions, you don't know what they did or what they were doing it for. You don't know who the parties were. But some of the entries represent defense of state action. But there's also individuals named where they're fighting a defense for individuals that brought cases. And since it's included in the coal ash litigation expense area, I think the only reasonable conclusion that I or members of this commission would be, all right, This is litigation by some individual for coal ash litigation. Now, to the extent that there was this massive discharge, the company pled guilty to criminal negligence, which is this recklessness or carelessness that shows a thoughtless disregard of consequences or heedless indifference to the safety and rights of others. And then when I see entries of private lawsuits that, based on the limited data, I think it calls into significant question whether or not a representation that they're not seeking recovery of those costs is accurate. So with that foundation, when I looked at these documents, because I literally had to go out and get this because I felt like I would.
You're talking about what's been marked as Exhibit 71?
I'm talking about all the documents that I came. Now, remember when I didn't have those documents when I filed my testimony.
Right.
But the documents that I looked at, if the same formatting and given their computer system and the significant limitations it placed on actually telling you anything, I don't think the addition of a pile that size or a pile that reaches the ceiling makes a difference.
Well, would you take a look at them just for a moment? I think the chairman's going to give us a break here in just a minute. Would you be willing to take Exhibit number 71 and look through them and tell me, since you haven't, have you seen these documents? Do you know? Have you seen them?
I believe they came in late after my testimony was filed, but I did look at them.
You've had a chance to review them? Could you do that on the break? Because I'm going to have some further questions for you as it relates to the documents that have been entered into evidence. And when we come back from break, if that's all right with the chairman. Would that be agreeable to you, Mr. Ham?
I am ready to respond to any question that you or any member. That's why I'm here.
I want to be sure that you've seen the documents that are in evidence before I ask you about them. So,
right. I'd be happy to do that.
All right, we'll take Mr.
We're not
Chairman.
going to take a break yet.
Not yet, but we'll take one, perhaps.
Commissioner Whitfield.
I've got a couple of questions for each of you, and Mr. Ham, mine, I'm going to go with you first. Mine won't pertain to that. We won't need to reference or take a break or anything, but I do want to be careful how I ask this. I do think this is a unique opportunity with you being the policy witness and with your background in ethics, and I hope your counsel doesn't jump up on my brief questions for you, but possibly counsel for the company, but I'm going to toss it out here anyway. And if there needs to be, there needs to be.
I'll do my best to answer any question you offer.
Mr. Ham, yesterday I had an exchange with witness Whitliff, and I think you were in the room in here yesterday. And Mr. Bateman put up a statute about this commission being able to enter into an agreement with any other state or federal regulatory body, which, did you see that?
Yes. It creates the possibility of it, and it does not require it.
Yes, sir. And I'm certainly was aware of that and aware of that statute. I think what caught me off guard is Mr. Whitliff, in my exchange with him, sort of implied that we could have a, quote, offline meeting with the North Carolina Commission, and there is where what led to my hesitation. With your background in ethics and your being the policy witness, if you will, among other things, for ORS, and again, I'm certainly aware we could enter into an agreement with other state or federal regulatory bodies. What could this commission do now that North Carolina has already ruled on the case? What could this commission do that might help ratepayers in conjunction with another regulatory body or any state or federal body, now that the North Carolina case is over? What could this commission do to help South Carolina ratepayers in that regard?
Well, I'll say initially that I think it would be improper for anybody on the commission to have a conversation with the commissioner staff in North Carolina while there's a pending hearing and this commission has not rendered a decision. Any conversations that you might have that even create the suggestion that your decision might be influenced by that conversation, I think would be improper. It is not improper for you to be advised of and be aware of the terms of the North Carolina decision, but I think that would be the absolute maximum that you could do, in my mind, lawfully and under the State Ethics Act, which you know I was the head of that agency for a little over a year recently.
And I thought that's where Mr. Whitliff was going when he made that suggestion. Yes, sir, go ahead.
So on that basis, if the question is predicated that the North Carolina has ruled, can you all have some contact with them in any way related to this proceeding, my answer would be a firm no.
Yes.
Now, after this commission renders its decisions, and I think would have to render both the DEC and the DEP, could you have general conversations about their regulatory policy? I think set up on the right basis. I think it would need to be noticed, just like you all have ex parte hearings. I think you could certainly do that. Do I think that's a good idea? You know, I know this commission is an active participant in NARUC. I support the commission doing that because it's important to understand and talk to the people that make decisions in other jurisdictions to help inform you, well, I hadn't thought about it that way, and apply that kind of reasoning. So I think that's the clearest answer that I can give you. But I do want to let there be no misunderstanding. I think it would be improper for the commission to have any contact in that way. And if that were to happen, I think the company would certainly challenge it, and I'm very confident that they would be successful.
Yes, sir. Thank you for your answer on that, Mr. Ham. Just one or two more, and then I got one from Mr. Morgan, and I'm done. Again, this is kind of more of a policy question, so if there's an objection, I'll see. But a lot of debate about the basic facilities charge, the fairness and equity. But there's also been a lot of testimony in this case about ratepayers in the DEP service territory being low income, and being not only low income, but those who are the least able to do something about their energy uses despite all the DSM and EE efforts. With that in mind, what's your opinion on the lower basic facilities charge and the company trying to make up the revenue requirement in the usage portion? Volumetric, yes, sir.
And the ORS witness, Michael Seaman Wynn, testified on that yesterday. And I want to start with the position ORS has taken, then I'll go a little bit farther, I think, to be in response to your question. Ultimately, this case is about revenue. And then once you all determine an increase, if any, how do you collect it? The basic facilities charge, and you also heard from Dr. Roof yesterday as well, the basic facilities charge is it certainly has cost basis to it, but I think the commission needs to proceed understanding that every time you raise the basic facilities charge, you're having somewhat of a negative impact on especially low income, low consumption customers being able to control the savings I get from trying to avoid the next kilowatt. They've got 500. If the basic facilities charge is higher and the commodities charge is somewhat lower, it's hard for them to see a price signal. And ultimately, what I think is going to happen is people ultimately are reacting to their total bill. I think that the commission, and I think it might have been you yesterday that talked sort of where does this end? We were talking about costs and other things.
And that was going to be my last question to you, so go right ahead.
Oh, man. Well, again, I am trying to be absolutely careful that I am making what I think is the best and most honest response to your question. I think our witness, Dr. Michael Seaman Wynn, Dr. Roof, made some very important points to the commission. And since this has come up and you've asked me, there was some question by counsel for Duke yesterday. Well, wait a minute. Dr. Roof's testimony is somewhat different than Michael Seaman's Wynn. And to some extent, that's true. But you need to understand that ORS, through our director, Annette Edwards, was trying to give the commission a little bit broader background to help you make decisions. And because as you recognize, we did not offer a specific number. Michael Seaman Wynn's testimony was intended to say, to the extent that you give it an increase, whether it's $1 or whatever, he basically said, that no more than 25% ought to go to the basic facilities charge. I think Dr. Roof testified that he thought it shouldn't increase at all. And that is one of those basic foundations that this commission is going to have to rule on. And I am personally, and I thought the idea of bringing Dr. Roof with a slightly different viewpoint, and he has years of experience. He's been over here many times. I've known him for 35 years. I think he made an effective presentation, whether the commission does or not, but he was trying to point out what the impact on low-income people, and it's true. There's a lot of citizens that out there are deciding, well, do I pay my power bill or do I get my medicine or whatever? And I'm not trying to intrude into that, but both ORS and through the testimony of Michael Seaman Wynn and the testimony of Dr. Roofer, we're just trying to lay out what some of those consequences are. And I think both ORS through Michael Seaman Wynn and through the testimony of Dr. Roof are clearly indicating some caution in those increases, because we had the word gradualism. Certainly an increase of several 100% in any component of an electric bill is, I think, would not serve all customers well to begin with, but I think that kind of an increase on the low income, low consumption people would be against the public policy of having people buy less electricity. So you're trying to slow down consumption. So you're not building another, either a peaking unit or a base load plants, because any of which are very, very expensive. I hope that was responsive to you. I'm not sure what else I can say to you, because I am not the witness who testified on basic facilities charge. What I have said is a culmination of my discussions with Michael Seaman Wynn and the materials I reviewed from Dr. Roof.
Okay, we're going to take a break. Now, you told us you've seen these a couple of you told us twice you've looked at these, but you get a chance right now if you need to, so you can answer anything else Commissioner Irvin needs. And we're going to take a break, and we'll be back. Commissioner Whitfield still got questions, but we're going to take a 10, 15-minute break.
Yes, sir. I'll be here, I promise.
Okay, we'll call us back to order. Commissioner Whitfield, I think you had another question.
Yes, and thank you, Mr. Ham, for your answers. That was pretty much it. When you made the comment, where will it end, I was referencing the coal ash, but you've really answered my questions, and I appreciate it. Mr. Morgan, I do have one for you. On page 5 of your pre-filed direct testimony, you propose eliminating the expenses in the highest and lowest years. I'm talking about storm costs now, to use an 8-year average expense level. Do you see large variances in the highest and lowest years, or are they somewhat in line with the remaining information?
Yes, sir. There was some variance. For example, 1 year, that number was 0 in 2012, and in 2016, that number was a little over, about a little over $29.5 million. So those numbers varied, and I think, given our recommendation, that was.
To use the 8-year average.
Right. Well, using a 10-year average, but only using 10 years of data, but using only 8 of those 10 with the lowest and highest removed.
I see. That's all I have. Thank you, Mr. Morgan. Thank you, Mr. Chairman.
Thank you. Commissioner Hamilton.
Thank you, Mr. Chairman. Good morning, gentlemen.
Good morning, Commissioner Hamilton.
I had hoped I wouldn't see you in the afternoon, but we might.
Well, it's still morning.
We're always
Yeah,
happy to
still
see
now.
you.
Got a few minutes. Mr. Morgan, I've got one question for you. Did the ratepayers of South Carolina receive any benefit at all from the company violating the terms of the certainteed contract?
No, sir. The violation, them not adhering to the agreement, no, sir.
None whatsoever.
No, sir. They benefited from the contract as it was written initially, of course, with the payment received from certainty that was outlined in the contract. But the breach of the contract, no, sir.
All right. Thank you, gentlemen, very much. Appreciate you being here.
Thank you.
Thank you. Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Ham, you've had a chance now on the break to review the documentation that was marked as next exhibit.
Yes, sir, I did.
What can you tell us about it?
Well, actually, I have a couple of reactions to it. Number one, I think it is amazing that shortly before the hearing, they suddenly come up with all of these documents. And I didn't react well to an assertion in one of these that, well, if we just ask the question, well, we believe we asked the questions. When you ask for invoices and as you'll recall, what they originally did, they just gave us an invoice number and what the dollar amount, and that was it. Now, I certainly wonder in management of Duke, who thought that could possibly be, forget the ORS. I don't know how anybody could have thought, well, the commission will know what that expense is and what it's related to. I don't have mind reading skills, nor should I, in a matter as serious as this. So I think this is, in many cases, they've given us a lot more documents, but my reaction is very much the same. If you look at any of the particular pages and you see these lists and lists, you still don't know. One thing that I noticed that they hadn't said to us in the beginning is we originally expressed concern about this historic treatment of insurance coverage and pollution control. I'm trying to remember the exact phrase. I saw a page in there that said that they were looking into and making claims on third-party excess coverage, and I'm familiar with what that means. But I want to go back to the point that what prompted all of this? What prompted all of this was Duke had a major disaster accident at Dan River with, well, you already know, the 39,000 tons and all the water. And it's very difficult for me to believe that these are not related to that, to which they pled guilty to criminal negligence. And I could certainly see why an insurance carrier would say, wait a minute, you pled guilty to criminal negligence, and we have provisions in our policies where you engage in conduct or result in judgments in certain areas, you lose your coverage. So it's difficult for me. I don't think it is being accurate on the record to say, oh, we're not trying to collect anything related to the Dan River accident. I think the consequences of that are flowing through these. There's a limited glimpse when you see actions filed by citizens related to that. Again, we don't know any of the details. We don't know who the parties are. And I think it's, I'm still having a problem when they say they're defending state actions against them. One of the things that really jumped out at me yesterday listening to the hearing, which I thought was pretty, was subtle, and I'm glad I'm getting a chance to make this observation too.
We're getting beyond what we were talking
I'm just
about.
trying to respond to his question, and I'll stop.
I guess.
Well, finish your thought. And
Well, witness couple has said, well, we didn't plead guilty, or they entered into settlement agreements. They ended up doing whatever the regulatory agency or the state government did, and they're saying because we didn't get to a judgment, we settled and had to pay certain costs, therefore ratepayers ought to pay for all of it. And I strongly disagree with that, but there's no way to know on this record what they are.
thanks, sir.
Yes, sir.
Those are all the questions I have.
Commissioners, any other questions? Commissioner Belser.
Good morning, Mr. Morgan. How are you?
Good morning, Commissioner Belser.
You had some testimony on the amortization of the AMI meters, I believe.
Yes, sir. Yes, ma'am, sorry.
Thank you. And I believe it was 15 years is your proposal,
Yes,
and you're tying that to the service life. Is that
Yes.
correct?
yes.
Now, as far as depreciation rates for those AMI meters, will that be the same term, 15 years?
Yes,
Okay. Thank you very much.
thank you.
Thank you. Commissioners, anything else? Any other questions? Mr. Knowles, any redirect?
No, sir. Thank you.
Thank you. Gentlemen, thank you for your Yes, sir.
Follow up on some of the commissioner questions.
I would object on the grounds that there's no recross if there's no redirect. Oh, I'm sorry. I would object on the grounds that we typically do not allow. Oh, thank you. Thank you.
Thank you, Ms. Edwards. Mr. Chairman, ORS would object on the grounds that if there's no redirect, there's no recross.
Briefly.
Thank you, Mr. Chairman. Mr. Ham, as you look through Exhibit 71, it sounds like you found that there was, in the stack of documents, narrative explanations of the various litigation matters.
I found wording. I didn't find wording that the standard that I apply is, would the commission understand what this means, since the substantial evidence rule. I found narrative. I didn't find it to be particularly illuminating as to what was going on.
But it's not all spreadsheet material, correct? You found narrative discussion of litigation.
In fairness, the answer to that's yes.
Thank you, sir. And would you agree with me in the future, that it would be the best way to get answers to the kind of questions that you were talking about is what's the litigation about? Does it arise out of Dan River? Does it not? The best way to get at that is not to ask for legal invoices or to go through legal invoices, especially redacted legal invoices. Do you agree with that?
Not necessarily, no.
Okay. Well, you understand that ORS asked for legal invoices. We talked about that.
And
last
we
time.
didn't get, we got a cover sheet. We didn't get any information as to the services rendered, what was rendered behind the numbers. I mean, I was honestly shocked that the company thought that giving us invoice numbers and dollar amounts in any way provided the commission with information supporting what you're asking for. I'm still puzzled and amazed, and what 71 is in many respects more of the same.
You agree with me that the commission's decision on the issues presented in this case are based on the record in this case, which would include testimony from the company's witnesses who talked about these various issues, as well as testimony from the ORS. Correct, sir?
After 40-plus years, yes, I think the commission must make a decision based on the evidence in this case and no other source or data. I'm just telling you.
Yes, sir.
I don't see how the commission can get there on what you put in the evidence.
Well, the commission also has the testimony of Mr. Karen and Dr. Wright and
I'm not contesting that.
Thank
Hey,
you,
let's
sir.
don't start talking over each other because Ms. Tackett's not that good. She's great. But, okay, we're done.
She is great, Mr.
Thank
Chairman.
you
I'm
for
sorry.
thank you for your testimony, and you may be excused. Is there anything else? Ms. Edwards.
A couple of just cleanup items. One, I do want to make sure that we got in the stipulation on prepaid. ORS had a witness, Sarah Johnson, but she will not be presented. And I think we moved in the prepaid stipulation, but if we did not, it was e-filed with the commission. If it was not, okay.
I don't think we did, so.
Okay.
all right, so
Is
we'll
there
do
any
that.
No objection.
Okay, so that's one item.
Okay, we will enter that stipulation as, what is exhibit number 72? Is that the way you would do it? Okay.
I just wanted to make sure I got that on the record. The second item, it was pointed out to us, we did e-file a stipulation on certain accounting adjustments, which we referenced yesterday. We had an agreement in principle. We did execute that agreement, and it was e-filed with the commission this morning. In that version that was filed, it erroneously referenced in Exhibit 1. We have since, over the break, fixed that error and e-filed with the commission and removed the reference to an Exhibit 1. With that, I think that concludes the what I will call the cleanup items.
I agree.
Thank you.
Yeah. Should we enter that in the record, just since we enter prepaid?
Yes. And
Yeah, that's what I was going to ask.
if-
We enter that stipulation.
if it pleases the commission.
Yes, we will enter that as exhibit 73. Okay, Ms. Edwards, anything else?
There, I did discuss with a court reporter. I have not discussed with opposing counsel, but I was asked about an exhibit that was marked but not moved in. That was a hearing exhibit 24, but that is related to the items in the stipulation. So I'm not seeking to move that in.
Okay,
Thank you.
thank you. Smith?
That's it. Thank you.
Okay, thank you. Okay. Okay, Mr. Stark.
I think the only outstanding administrative matter or procedural matter that we have relates to proposed order dates, which, per our conversations earlier, it was mutually agreeable. I think May 1st as a proposed order date. Does that remain true with the parties?
We'll meet no due date.
Okay, May 1st. Thank you.
Everybody's good with that?
One clarifying question.
Microphone.
One clarifying question. Just to get as much time as possible, is that close of business or possibly midnight?
Yes, please do.
Midnight would be fine. And I should add that in addition to proposed orders, the commission will receive briefs either in lieu of or in addition to proposed orders.
Anything else? I thought you were going to say midnight is preferred. Anything else? Okay. Thank you for everyone for your testimony and your time, and we are adjourned.